What am I talking about? I'm talking about indirect discrimination. And there's a reason that I've titled or entitled this talk, Indirect Discrimination, or Is It? And the reason for that is because I want you, and hopefully by the end of this seminar, it'll probably be obvious what I think the answer to that question is. But I'm hoping that when we go through some of the points to do with indirect discrimination, you also will have formed a view on whether or not you think indirect discrimination is actually able to be called indirect discrimination anymore. And hopefully by the end of it, you will have the ability to think more outside the box than we might otherwise have done hitherto when it comes to indirect discrimination. Because, not to give the game away, so to speak, but I think there's a whole world of litigation potentially out there when it comes to indirect discrimination as we now know it. I'm not going to stand here and talk at length about Brexit. We all know what Brexit did, and we all have our views about Brexit. But Brexit, as we all know, had a substantial impact on the law when it comes to indirect discrimination. That was all fine and dandy until we had Brexit. And we went into a position where no longer could, or do the rules as to interpretation of law apply. So what we are left with was a change in the Equality Act at the start of 2024 by virtue of the Equality Act 2010 Amendment Regulations. And it's that change which I think is more significant than otherwise we may have thought it would be. To my mind, it brings very much to the fore, particularly to Google lawyers and litigants in person, a new way to challenge their employers. And I think we all, whether in claimant or employer lawyers, need to be very much alive too. So I'm going to start off by really teaching grannies, as it were, how to suck eggs. And I'm going to remind us all of what Section 19 of the Equality Act actually is, because without reminding ourselves of that, I'm not going to be in a position to persuade you as to my view as to the initial question that I posed us, indirect discrimination, or is it? So Section 19 of the Equality Act, I've put it up there, and I'm hopeful that you can read it. We've got a few screens around the room, but it does as well for us to remind ourselves as to what it is, very briefly. Indirect discrimination occurs where we have a PCP. That PCP is applied to those who both share a protected characteristic and those who do not. It puts or would put, and I'm going to underline that because some people forget about the or would put part of the Section 19 test. I know I've seen people forget that. Persons with whom B, let's say the employee, shares the protected characteristic at a particular disadvantage when compared with persons with whom B does not share it. And then the next requirement, which normally follows, I say, from the previous, but it puts or would put that person at that particular disadvantage, i.e., the person with the protected characteristic is put to the disadvantage. Now, I don't need to tell everyone this, but the archetypal indirect discrimination example is I would say, the indirect sex discrimination. So the requirement for you to work full-time and or on a Saturday, for example, which indirectly impacts females because females are more likely to be primary child carers versus males who are not. There is case law out there which, whilst it's not taken as a given, it's almost taken as a given. It's a social norm that is the case. And if you are a female employee who is impacted by that, you've got yourself an archetypal indirect discrimination claim. Now, it's as well, again, to remind ourselves of some comments from the Supreme Court in Homer and Chief Constable of West Yorkshire Police. And I'm going to read a quote because, again, it resonates, I think, when we go through this seminar as to whether this actually now can be said to be true and stand as to what indirect discrimination actually is. In that court, in the decision, my apologies, it says this: the law of indirect discrimination is an attempt to level the playing field by subjecting to scrutiny requirements which look neutral on their face, but in reality to the comparative disadvantage of people with a particular protected characteristic. I've got in big, fat, bold and underline, comparative disadvantage, people with a particular protected characteristic. The resulting scrutiny may ultimately lead to the conclusion that the requirement can be justified. And we are all probably familiar with the Aesop case where Lady Hale gave, and she herself emphasized the requirement and the purpose behind indirect discrimination being to level the playing field. It's about where people sharing a protected characteristic, a particular protected characteristic, are not subject to requirements which many of them cannot meet, but which cannot be shown to be justified. And again, the emphasis, and we're talking about Section 19 of the Equality Act, the emphasis being the equality of results. It is very much about, as Lady Hale would say, levelling the playing field. And that really was, it strikes, the purpose behind Section 19. Now, that all sounds great, doesn't it? That all sounds fantastic. What's wrong with Section 19, or what was wrong with Section 19 of the Equality Act? Why on earth did our good old drafters of the legislation need to do anything with Section 19? Because it does what it says on the tin, doesn't it? It does what Lady Hale says it should do. It levels the playing field. It makes everyone have the same level of advantage in the workplace. It didn't need touching, or did it? Now, this is one of the most interesting cases, and perhaps unusual cases, I've seen come to cause a great deal of upset or change in employment law. And it's the case of Shea. I do quite like to go into this one because for the life of me, I cannot understand how this case, as I say, has caused so much upset. Now, briefly, the facts in the case of Shea were that there was a lovely Miss Niklova. She owned a shop in what was a predominantly Roma district in a Bulgarian town. She herself was not Roma, so she didn't have the protected characteristic of the disadvantaged group, which we're going to come to. Now, what Ms. Niklova complained of was that the practice of electricity distributors, and I'm reading from my note to make sure I get this right, the practice of the electricity distributor of placing meters in that district on concrete pylons at a height of between 6 and 7 meters. And she couldn't monitor her electricity consumption or check her bills. So that, realistically, was the set of facts which gave the backdrop to the decision in Shea. And that decision of the European Court of Justice in Shea held that the practice of placing meters at that height could amount to indirect discrimination, even though she wasn't someone of Roma nationality. I think the logic behind it was there was a lot of criminal behavior going on in this district, in the Roma district, and the reason they had to put the electricity distributors so high was so that people couldn't tamper with them and people couldn't destroy them, I think is the logic. Poor Ms. Niklova couldn't reach her electricity meter. So that decision then in the European Court of Justice said this: the principle of equal treatment in the directive is intended to benefit also persons who, although not themselves a member of the race or ethnic group concerned, nevertheless suffer less favourable treatment or a particular disadvantage on one of those grounds. That principle applies not to a particular category of person, but by reference to the grounds mentioned in Article 1. That's of the European legislation, which essentially underpinned our indirect discrimination provisions. But it strikes me that there are some important points within that decision in Shea which help us understand why we get to a position of Section 19 of the Equality Act actually needing to be amended. And interestingly, if you flick through your handout I've left it in highlight towards the end of paragraph 102 of the decision. And there's a bit there I'm hopeful it's been left in highlight and underlined. In other words, it must be clarified whether it is permitted by law to accept the existence of discrimination by association in relation to indirect discrimination. Shea claims that discrimination by association can be taken to exist only in relation to direct discrimination, but not in relation to indirect discrimination. I do not share this view. It may be that the court has thus far only had the opportunity to consider the problem of discrimination by association with reference to a case of direct discrimination. However, this certainly does not mean that it would have ruled out the existence of discrimination by association in the case of indirect discrimination. Now, this is where this phrase, discrimination by association, comes in. And I'm going to tell you all in this room, put that phrase out your head. It's a horrible phrase. It's not the right phrase. I think there's a lot of cases, there's a lot of guidance since which says just ignore the phrase discrimination by association because it creates confusion where confusion does not need to exist. But the reality is this. When we reach and we have the decision in Shea, because what Shea was really saying was, well, indirect discrimination should be capable of applying even to someone who isn't, I'm going to say, in the minority group. So let's go back to section 19. In order for, on an ordinary archetypal section 19 claim to succeed, you need to fall into B. So you need to have a group, a comparative group between people with a particular protected characteristic. Let's use my example of females as primary child carers versus males who are not. So the disadvantaged group there are females when you can't comply with your requirement to work full time. Males, I'm going to say, are in the majority group. Again, that's a colloquialism because it doesn't always fall that way. It doesn't always have to be a majority versus minority. That's just me trying to explain it in a more easy understanding way. And it also needs to put you to that disadvantage. So that requires, in order to succeed, the person to have the particular characteristic. It requires, in my example, the employee to be a female. But how on earth do we, using share, get away from that? How on earth can that be applied to the situation in share? When share told us we had to give rights to people who suffered the same disadvantage, even if they weren't, in my example, female. Well, the way we did that was previously we had lots of lovely EU law principles, which again I've set out in your handouts, which give the courts quite a wide and broad-ranging discretion to read down, to reinterpret, and frankly, I'm going to suggest possibly even reword legislation in order to give effect to European legislation. And it is fair to say, and I think I'm able to say this because I did a case which we're going to come to, and I'm frowning because it was a case I would rather forget. But we did a case, and there is case law, and there are lots of employment tribunal decisions where tribunals have felt comfortable and able to, or did feel comfortable and able to interpret Section 19 to allow for the share, same disadvantage type discrimination. I will say this, for the life of me, I do not understand how anyone can read Section 19 as requiring any other than there need to be a comparative group and you need to be in the group which has suffered the disadvantage. I do not understand how Section 19 was capable of being read in any other way. But Shea told us we had to do that, and that's what tribunals did. So, lo and behold, end of Brexit, end of interpretation obligations. We need some new legislation. Hurrah, perhaps I am right. Perhaps other people thought likewise that Section 19 couldn't be read in the way that Shea required us to read it. So in comes Section 19A. So what the drafters did was they didn't change, probably because they couldn't, because it was impossible to do what the tribunals had hitherto been trying to do in the face of Shea. So they had to add a new Section 19A. So whenever we talk now about indirect discrimination, we have to remember, are we talking about Section 19 or are we talking about Section 19A? It's kept the same heading, still indirect discrimination, but it does what it says on the tin. It's the same disadvantage case. So what is it? But before I do that, actually, before I look into this, I want to spare a thought for, and I say spare a thought for because this probably will start giving away the outcome in a case I dealt with. What about have we heard of the family friends category? So when it comes to indirect discrimination, you've got two categories of discrimination by association. You have the same disadvantage, so where there is a discriminatory, an indirectly discriminatory provision, but you suffer the same disadvantage, albeit not part of the protected group, the protected characteristic, and the minority. And then there was attempts, including by me, to argue that there was room for, within the old Section 19, what I'm going to call the family friends category of discrimination by association. And there is a tribunal decision, which may have caused a bit of excitement in the case I did, where that succeeded, actually. It was a first instance decision, because the family friends category is this. It's where you, for example, and I think this is better expressed by an example, imagine you are the carer of a disabled child. And you have a requirement, for example, to work 4 days, 5 days in the office. Now, as a carer of a disabled child, that is likely to put you at a disadvantage by comparison to someone who isn't the carer of a disabled child. So this is where I think this phrase discrimination by association got everyone a bit excited. Maybe everyone got a bit carried away with, okay, right, we can run these claims because I'm associated with someone who has a protected characteristic. I myself am not in the category of people with a protected characteristic, but I am associated with someone who does. A very different scenario to the same disadvantage type scenario. This is the family friends. I think I can cut through this. To my mind, Section 19A, which we are going to go through in a little detail now, kills dead the family friends, in my view, kills dead the family friends category of indirect discrimination. I think it's very difficult to try and argue that there's room to play with in Section 19, and certainly not Section 19A, the family-friendly type argument. So what is Section 19A? Now, Section 19A bears reading very carefully. So a person A discriminates against another B if A applies to B, a provision, criterion, or practice. We remember that from Section 19. A also applies or would apply the provision, criterion, or practice to persons who share a relevant protected characteristic and persons who do not share that relevant protected characteristic. So far, so good. We all know what these principles mean. We've dealt with this in Section 19. C. B does not share that relevant protected characteristic. Already, we've got a very big departure from the previous wording of Section 19. We've got potentially even the opposite of our old Section 19 here. D, the provision, criterion, or practice puts or would put persons with the relevant protected characteristic at a particular disadvantage when compared with persons who do not share the relevant protected characteristic. Okay, fine, we remember that. We've got that from old Section 19. And then E, the provision, criterion, or practice puts or would put B at substantially the same disadvantage as persons who share the relevant protected characteristic. Totally different to Section 19. So what we've got here in Section 19A is a scenario which allows for there to be indirect discrimination even where the person who's claiming doesn't have the protected characteristic. Now, you may think, oh, what's Crammond talking about? You know, he's emphasizing this from Lady Hale, he's emphasizing this from Section 19. There's a reason for that, because to my mind, this is now a wholly different indirect discrimination. This, in my mind, isn't about leveling the playing field. It's not about giving quite properly the disadvantaged that leg up, so to speak, they require and absolutely need in order to put themselves on a level playing field. This gives rights to those who weren't otherwise privy to the disadvantaged group in Section 19. Now, I have my own views on that as to whether that is something which, frankly, was intended by Section 19, whether Lady Hale would have thought that when she was giving her judgment in Aesop, we'd ever be in a position where Section 19 applies in this way. And I think the logic behind it is to just get rid of anything that's indirectly discriminatory. So we give this extra protection and it gets rid of anything which is an indirect PCP, or indirectly discriminatory PCP. But it seems to me that this now is very much not a flying in the face of, but it's a very much new brand, if I can call it that, of indirect discrimination. So, in terms of what does it mean? Now, right, imagine this, and this is outlandish, but bear with me. There's a requirement to work on the second floor in a building with no lifts. Now, imagine we're back in the 1960s for a second, and we've got no lift. Comparative disadvantage. So imagine someone's disabled, perhaps they're an amputee, they're in a wheelchair. That person obviously cannot require or cannot comply with the requirement to work on the second floor because they can't get up the stairs and there's no lift. By comparison to the non-disabled person who is, or who isn't an amputee, who is able to do that because they can walk up the stairs, for example. Now, imagine this. So far, so good. You know, we've got ourselves the making of an ordinary Section 19 indirect claim. But what about this? What about a guy who works for his employer, same building, required to work on the second floor, no lift. He goes out of the weekend with his mate, plays football, breaks his leg. And he's broken his leg really badly, but it's not going to last long enough to be a disability. Perhaps he's broken his leg and it's going to be out of action for 6, 8, 9 months. And that's what the medical evidence says. This guy, for example, isn't able to come into work because he can't get up the stairs to go to the second floor where he's meant to work. And he's put through capability proceedings, he's sacked. Now, why isn't that man, using Section 19A, able to claim indirect discrimination? So let's work through it. A applies to B, a provision, criterion, or practice, the requirement to work on the second floor. This is applied to everyone. So it's applied to disabled people, so amputees, as well as those who are not amputees. C, he doesn't share that protected characteristic because he's not an amputee, he's not disabled by reason of being an amputee. But it certainly puts him at it puts disabled amputees at a particular comparative disadvantage to those who are not disabled amputees. And the PCP puts our guy, Mr. Broken his leg while he was out playing football, at the same particular disadvantage as the amputee who can't get up the stairs because he can't walk to the second floor. Why is that not the makings of a highly unusual Section 19A claim? It feels wrong, I'll be blunt. It doesn't feel right. It feels like it shouldn't apply, but it depends how you frame the disadvantage. But the disadvantage is not being able to go up the stairs, not being able to comply with the requirement to work on the second floor. Now, it seems ridiculous to all of us, doesn't it, that could possibly be an example that would work in our tribunals. But I think to myself, why not? And that's what I really want everyone to be thinking. There's another example I'd give, and I'll try and rattle through this one a bit more quickly. So this one I took from the case of ESOP. Now, the case in ESOP was the case where there was a requirement to pass a skills test ultimately. The skills test, for reasons which I think were unknown actually, but not that it matters, had a disparate effect on a particular racial group. So in that case, that was indirect discrimination. It mattered not why there was this connection, but there was this connection. What about, for example, the white employee who takes the same test but fails? Why doesn't that indirectly discriminate under Section 19A against that very employee? The disadvantage being not passing the test, not getting the job. I'm not sure whether anyone, and I really am looking forward to this coming through the tribunals, because to me, I struggle to see how you could say that that person isn't. There might be a justification point, that under Section 19, the focus and the real steer in all of these is likely to now become, I think, the justification, because you can see a tribunal being desperate to want employers to be able to justify the kind of ludicrous examples I've just given us here to try and emphasize the point. But the reason I mention it is because it really now does mean that if you're acting for claimants, there's fertile ground for claims here. If you're acting for employers, your employers need to drag out all their policies, look at them again, revise your policies. They need to be again looking at, we need to keep records, we need to keep a logic, we need to keep our emails, our documents, setting out all of our rationale and why on earth we say this is justified and why we need it. Because if you're not, you could perhaps unintentionally, as Section 19 is capable of doing, but Section 19A really, to my mind, broadens the scope for claims against employers. And I think it's opened up a potential risk to employers in terms of their policies and procedures being challenged on indirect discrimination grounds, whereas hitherto they weren't. And so I asked the question at the beginning, indirect discrimination or not? I did say I was likely to be obvious, but I was giving this seminar what I think the answer to that question is, and I think the answer is not. Certainly not in the way Lady Hale envisaged, and certainly not in the way which Section 19, as we all lovingly know it, envisaged.